Hey everybody, it's Derek Christensen here from Legion Law. I wanted to make a video today about why blended families can be a concern for estate planning. So, before I dive into that, I wanted to let you guys know where you can reach out to me. You can email me directly to me, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, legionlawpllc.com. The contact us page, you can set something up immediately. So, with that being said, let's dive right in. So this is a potential client that I was working with actually over the weekend, and she calls me and needs an estate plan. Her father is passing away here soon, and it's kind of more of an emergency situation than anything. Unfortunately, the father is in the hospital. Things don't look optimistic. So she was asking me questions about what kind of estate plan does she need for her father, and how can we make sure things are smoother than what they would have been without the estate plan. So we were talking, and I find out that A, they don't have anything in place, and B, it's a blended family. And so I wanted to address that because that is a major concern for estate planning. And I wanted to make sure that everybody's on the same page because essentially the theme of this video is if you have a blended family, it's almost mandatory to have an estate plan in place, at least in Texas. So let's first dive in. What's a blended family? A blended family is simply a person has children with multiple people, and then the family, whether or not they get together and are married and all that stuff is different. But if you have children with multiple people, then you're going to have a blended family. Now, in this particular case, my client, she and her brother were from a first woman. The man got remarried, and with the second woman had another 2 children. So that's 2 children from one family, 2 children from another family. They live together, blended. So in that circumstance, if you do not have a will, and at least in Texas, then there are major concerns because in Texas, there's called intestacy, the default laws that apply for whenever you don't have a will. And intestacy is, those laws were written back in the 1870s whenever people were concerned after the revolution of Texas and we became the Republic of Texas. People were concerned that their cattle ranches would go to the children of the new wife. So in other words, they're big on property. They're big on property rights. They fought the Mexicans for it, and they got their land, so that's great for them. But their laws reflect a very large concern that a man would own a ranch, he would get remarried, and then the new spouse's children would get all the land, and the land would leave outside the Texan's home. So whether or not that's right, whether or not that's a valid concern, nonetheless, that's the current laws that are in place. And I say all that because essentially, if you die without a will in Texas and you're part of a blended family, then a lot of strange things happen, but essentially the wife or the spouse will get 1/3 interest in any real property, meaning a house or land. So the spouse will get 1/3 interest in the property. The children from both marriages will have to split the house up and the land up by 2/3. And once the spouse passes away, then the 2/3 property will go to the children, and the children will have to determine how to split things up. Now, I know that sounds kind of strange. In addition to that, the separate property of the decedent, the guy who died, is going to be split up differently. The community property, it's a mess. I don't want to get too much into it because it'll be like a 5-minute longer video, but at the end of the day, just trust me, it's a mess and a half to try to split up property between a blended family that does not have a will in Texas, because houses and land are treated differently than the furniture. The furniture is treated differently than the property spouses owned before they got married. And it's a real big headache. So essentially, if you don't want to have to give your children headaches, if you want to lower how much you have to pay for attorneys, if you don't want to deal with a huge mistake and burdens on your family, then you need to have at least a will in place. And a trust almost always will probably be a better option. So get an estate plan if you're a blended family, and be sure to make sure that in that estate plan there's at least a will or a trust, and that document clearly states whatever you want to have happen. Because in a will and a trust, you can just ignore Texas's laws and say, all my stuff will go to my spouse. After my spouse passes away, all of my children. Like, you could say that, and it'd be so much easier than the default laws that are splitting it up all these different ways to make sure all these magical things happen that were concerned back in the 1870s. So, again, I think Texas's laws need an update, but at the end of the day, it is what it is. That's what we're dealing with right now, and it's imperative that blended families have at least a will or a trust in place to make sure that no headaches and no problems happen in the future. So, with that being said, feel free to reach out to me. Like I said, I work with these kind of blended families and am working with one right now. And I'd be more than happy to draft a will or a trust or whatever else is needed to make sure that a blended family is protected in the future. So, that being said, reach out to me. My email again is Derek, DEREK, at legionlawpllc.com, or my website is www.legionlawpllc.com. So thank you so much, and you guys have a great day.